Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, Committee Room 30, signed. 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 Committee Room 30, sound. Committee Room 30, sound. Committee Room 30, sound. Committee Room 30, sound.
Thank you. Members, that's us now in public session. I don't know if there's some folks to come in. There's Bruna. Members, as ever, the committee meeting will be recorded and broadcast throughout Parliament buildings and online. I don't think we need to welcome anybody to the gallery who hasn't already been here for a while. Let me see. Yes, so this is our first opportunity to welcome in public our new member to the committee, Stephen Dunn. Stephen, you're very welcome. I'm sure you'll enjoy justice, and I have no doubt that you'll bring valuable contributions, so we look forward to working with you. And also, I'd like to take this opportunity to thank Sarah Ann. Sarah Ann has been with us for a while now, but she's moving on to pastures new in the Finance Committee, so we wish you well for that, Sarah Ann. And thank you for all your work for the Committee for Justice. Members, it's proposed that the oral evidence session with the Assembly's Research and Information Service and with departmental officials on Statutory Rule 2024-147, the Police Service of Northern Ireland and Police Service of Northern Ireland Reserve (Injury Benefit Amendment Number 2 Regulations 2024) will be recorded by Hansard. Are members agreed? Agreed. Thank you. Also, we are obliged to declare any financial or other relevant interests that might be reasonably thought by others to influence our approach to matters under consideration. Does anybody have any interest they wish to declare?
Chair, received correspondence on this issue.
Likewise,
held meetings as well.
Yes, I would record that interest also. And I'd also record that I have an immediate family member who works in the legal profession. Agenda item 3 is the draft minutes of the meeting held on the 12th of September. These are found at pages 18 to 30 of your meeting pack. Are members content that the minutes are a true and accurate reflection of the proceedings of that meeting on the 12th?
Agreed.
Could I just flag up a couple of things, if I may? Page 21 of the minutes. Let me just get myself to the right place. Page 21 of our packs. Yes, there is reference to trauma-informed practice. It's not that they're attached to APPROX. This is an individual specific organisation that is used across government departments about the implementation and advice around trauma-informed practice. So it's just to clarify and correct that. The other issue is on page 24 with regard to Sammy Wilson. And we'd agreed to seek further information around review, but we'd also agreed, if you recall, that we would ask for information around potential options for those who compete.
Oh, yeah.
Do you remember that?
Yep.
That's great, thank you. So are members content then to have those changes made?
Yes.
Agreed. Yeah.
Thank you. So with those then, once those are changed, then I'll sign the minutes. Just in terms of matters arising then, I'd refer you to pages 32 and 33 of the meeting pack for the relevant papers. At last week's meeting, the review of the Northern Ireland Policing Board had been raised, and the terms of reference for the review are included in this week's pack. Are members content to note the contents of this correspondence?
Noted.
Thank you.
Can I just raise a quick question? When did we receive that letter on? Did we, because we didn't know about it on the last meeting, did we? Did we receive it before the last meeting?
No, because did it not happen that day?
I came in during the meeting.
Yeah.
I mean, during the meeting?
Yeah.
Yes.
I mean, it's a no. I mean, I've got to say, I mean, the review has started, and we're now only talking about it now, where it was announced a week ago. And surely the Department of Justice understand the systems we work on, you know, our meeting pack and our table pack, and we could have been informed of this earlier.
Yes.
Because according to the letter, it's started now. And I have a slight concern I would like to raise, if I can, Chair, because, and I've raised this before and it's been raised in the Assembly, but in the terms of reference, one of them refers to the Schofield judgment. And within the Schofield judgment, there is an acronym used which he believes to be the Minister for Justice. And therefore it could be viewed that she's contained within that Schofield report. And I want to know if there's been any legal advice taken in regards to that, to see if she should be excused from this process if her name has appeared within the Schofield report.
Yeah, because you raised that in plenary and the Minister denied it, but we don't have any clarity.
And
Yeah.
it's not that I'm saying she's wrong.
No, but we just need
But
to
if there's
establish
a
what-
perception that it's named, and I'm also slightly concerned that I think she said in the press release that it'll be finished by December, but not in the letter. That's a pretty short review of what is a strategic function for policing. So I have a slight concern about that.
Well, how about then we write and ask those questions?
Yeah, please.
So are members content that we would do that, just write and seek clarification around some of those issues that Doug has raised? So that's issue around legal advice about, it's MJ or something it's referred to, isn't it?
MJ and Schofield can't figure out anywhere else what that would mean other than Minister for Justice, because the Chief Constable also refers to Michelle O'Neill as DFM. She was Deputy First Minister, so he uses those acronyms to denote. So, and it may be nothing to this, but if there is a perceived a conflict of interest, then I would like to know beforehand.
That's fair enough. So members are content, aren't they? Thank you. So we'll write and clarify those points and see what the department has to say. Also, another matter arising is Justin raised an issue about an article in the Belfast Telegraph regarding licence breaches of prisoners. So a copy of that article was emailed to members on Monday the 16th of September. Did everybody receive that?
Yeah, we do.
Yes. Okay, thank you. And Justin, thank you for bringing that to our attention. Agenda item 5 then is the Justice Bill and a briefing from Research and Information Services. I'd refer members to pages 34 to 123 of the meeting pack for the relevant papers. So just by way of reminder, members, the bill was introduced into the Assembly on Tuesday the 17th of September. The Justice Researcher from RAISE is in attendance at the meeting. Hello, Judith. And she's going to present her paper. So we'll hand over to Judith and then we'll take questions for Judith at the end. Judith, thank you very much for coming back and we appreciate all your work on this thus far. I'll hand over to you now. Thank you.
Thank you, Chair, for the invite to address the committee on the Justice Bill this afternoon. As members will be aware, the bill was introduced into the Assembly this week on 17th September. So there's a lot in the bill, and the purpose of this evidence session today is really to give the committee an overview, concentrating on key areas in each section. I'm going to aim to focus on highlighting what the current legislative situation is in each of the areas covered by the bill, the proposals for change contained within it, and some areas which the committee might wish to explore further as the bill moves through committee stage. I'll just say up front that a lot of this is complex and technical, and I probably won't have all the answers today, but I will aim to give the committee a starting point to work from as the bill begins its legislative journey. And hopefully this helps to build as well in your previous session with the Bill Office. And it's all supplemented by the paper in your packs as well, which covers everything I'm going to talk about in a bit more detail. So part 1 of the bill relates to retention periods for DNA and biometric material. So first of all, what is biometric data? I mean, generally, it's the term used for fingerprints as well as DNA profiles. So these are unique identifiers derived from a physical sample of DNA, which might come from blood, hair, saliva, etc. and biometrics can be used to identify a particular individual and are routinely used by the police in all kinds of criminal cases. They form a key part of the criminal justice process as they provide police forces and national security agencies with a vital resource without which a significant number of cases could never be brought to trial. However, the public interest in collecting and retaining biometric materials also needs to be balanced alongside individual citizens' rights, so particularly when we consider Article 8 of the European Convention on Human Rights around the right to respect for private and family life. The existing legal framework in Northern Ireland is found in Article 64 of the Police and Criminal Evidence Northern Ireland Order 1989, and this allows for the indefinite retention of biometric materials, including DNA samples, profiles, fingerprints and palm prints. There are also a number of databases which hold biometric data. So there's a national DNA database which holds material uploaded from across the UK. There's a local Northern Ireland DNA database. There's a national fingerprint database known as Ident1, holding fingerprint information from across the UK, and fingerprint sets are also held locally in the PSNI Fingerprint Bureau. Police also use other databases and intelligence systems across the UK, so the likes of the Police National Computer, which holds criminal record details and other information, and there's also the Police National Database, which holds custody photos, amongst other things. So I'm telling you this because the committee should be conscious that different retention regimes operate across the UK for biometric data, which is one of the reasons why this is such a complex area. So there are UK-wide databases, but different retention schedules, oversight arrangements and policies for data deletion, depending on whether you're in England and Wales, Scotland or Northern Ireland. So in recent years, there have been 2 European Court of Human Rights judgments relevant in this area. The first was Essen, Marper and UK back in 2008. This considered the retention of fingerprint and DNA data of 2 people suspected but not convicted of offences in England and Wales. And the court found that this was not necessary in a democratic society, and that the blanket and indiscriminate power of retention, regardless of the nature or gravity of the offence, absence of any time limit, lack of independent review, and restricted possibilities for acquitted individuals to have data removed or materials destroyed, contributed to a violation of Article 8. This was then followed by Gaughran in UK in 2020, and this case involved an applicant with a spent conviction for driving with excess alcohol in Northern Ireland, and the European Court held that there had been a violation of Article 8 due to the indiscriminate nature of the powers of retention for the DNA profile, fingerprints and photograph of the applicant. So there was no reference to the seriousness of the offence, the need for indefinite retention or any real possibility of review, resulting in a failure to strike a fair balance between competing public and private interests. So during this period as well, we also had the Criminal Justice Act Northern Ireland 2013, which aimed to create a compliant regime locally. However, it was not possible to commence the biometrics provisions due to the need to preserve material that might be required for future legacy investigations. So this has since been addressed under the Northern Ireland Troubles Legacy and Reconciliation Act 2023, and this included a power to make regulations to permit the retention of designated collections of biometric material that would otherwise be destroyed, and ensure that it's available for use by the Independent Commission for Reconciliation and Information Recovery during its lifespan. So the relevant regulations came into force in May 2024, and the committee may wish to consider how these will align with the new biometrics retention framework detailed in the Justice Bill. And just finally on this slide, it's worth being aware that the PSNI is currently operating an interim service instruction on the retention and deletion of biometric material. So this highlights that the service operates a biometrics ratification committee, and it can consider applications for deletion from both local and national biometrics databases. And this currently covers an applicant's DNA samples, DNA profile derived from any sample, fingerprints, palm prints, as well as any custody photographic images. So on to the bill. And Part 1 amends the Police and Criminal Evidence Northern Ireland Order 1989 and the Criminal Justice Act Northern Ireland 2013. And this section of the bill follows a consultation that the Department undertook in 2020 and that focused largely on maximum time periods for the retention of biometric data. So this has resulted in a 75, 50, 25-year model, which is reflected in the bill. So very broadly, this means a 75-year retention period for DNA and fingerprints for convictions for all qualifying offences, so typically serious violent or sexual offences, regardless of age. This is followed by a 50-year retention period for adults convicted of recordable but non-qualifying offences, with a custodial sentence of 5 years or more. And then there is a 25-year retention ban for adults convicted of recordable non-qualifying offences where there's been no custodial sentence. There's also specific provision for under 18s, as well as retention periods based on whether a first minor offence is applicable. And there's also provision as well for individuals arrested for a qualifying offence but not charged, or charged but then not convicted.
You have a slide on that detail?
I have
Is it in the pack
It's
anyway?
in the paper, so
Easily.
I've attempted to break it down in table 1 in the paper, so that should give you a full kind of overview of every kind of retention band and that's contained in the bill. So it's a bit too much to get it all onto one slide. There's also provision in the bill for a court to extend the retention periods, where the Chief Constable can apply to a district judge for an extension which is limited to 2 years at a time. The bill also highlights a requirement for the Chief Constable to review the continued retention of material pending the investigation of offences every 5 years. So this must consider whether an individual remains a suspect in the investigation and whether the biometric material has evidential value in the investigation or any proceedings. And the Department may make regulations specifying further factors which police must have regard to in conducting a review. The Chief Constable is also required under the bill to conduct reviews of the continued retention of long-term retained material, so that's material that's held for 25 years and over. The detail of this will be contained in regulations which the Department must provide for, and these may cover a range of matters such as when the review should be conducted, enabling the individual concerned the right to request a review, and conferring a right of appeal. So given the importance of a review mechanism in ensuring compliance with Article 8, and given the significant periods of time which personal data may be retained for, so 75 years, 50, 25 years, the committee might wish to consider whether more details around the review mechanism should be defined in the bill, potentially. This also then links to the appointment of a Northern Ireland Commissioner for the retention of biometric materials. The Commissioner's broad role will be to review the biometric retention framework, including the gathering, retention and use of biometric material. But the bill also appears to potentially confer some sort of review or complaint function on the Commissioner under future regulation in relation to the review of long-term retained material. So the committee might wish to consider whether the bill could be strengthened by providing a procedure in statute allowing an individual to make a complaint to the Commissioner in relation to their biometric data. So I've already made a few suggestions already for issues that the committee might wish to explore in further detail, but this slide provides a brief summary. So it's worth considering the 75, 50, 25 model in greater detail. The Northern Ireland Human Rights Commission said in its response to the Department's consultation in 2020 that this model is disproportionate and not compatible with Article 8. So it might be worth considering whether this model will allow for the retention of biometrics for an overly excessive length of time in the case of less serious offences. On the flip side of this, though, it might also be worth thinking about whether this model is overly complex and how exactly the retention bans will be workable in practice for organisations like PSNI responsible for biometric data. So the Justice Bill also doesn't include any specific provisions around custody photos. So the Department did not consider this as part of the 2020 consultation, but highlighted that PSNI policy has been to include them within the scope of the regime governing the lawful retention and deletion of biometrics. So the Department did not believe additional legislation was required in this area, but it might just be worth exploring that one a bit further as well. Slightly different approaches are taken around custody photos depending on which part of the UK you're in. So, for For example, Scotland's definition of biometric data does include photographs and recordings alongside fingerprints and DNA, but this is not the case in England and Wales. The retention of biometric material beyond death is another area worth potentially considering. The department proposed to delete all biometric material 10 years after the death of a person following the 2020 consultation, so it might just be worth clarifying how the bill gives effect to this and how this might operate in practice in terms of PSNI being notified of a person's death. And we also have the Northern Ireland Commissioner for the Retention of Biometric Material, who's given a specific role in relation to keeping under review the development of existing and new biometric technologies, which could be used by law enforcement authorities for the prevention and detection of crime. So there are a range of emerging policing methods which may be of relevance in this area. For example, live facial recognition technology. This has been used by, I think, 3 police forces to date in England and Wales, but human rights and data privacy concerns have been highlighted. So new developments in this area, driven by advances in AI technology, are likely to progress significantly in the coming years. And it's worth being aware that there is a Scottish Biometrics Commissioner, as well as a Home Office Biometrics and Surveillance Camera Commissioner, and these offices have both expressed concerns that the UK's legal framework is inadequate and in need of reform, principally because it's failing to keep pace with rapid changes to biometric technology. So, worth considering whether the bill is sufficiently future-proofed in this regard. So, moving on from biometrics, Part 2 of the bill covers changes relating to both police bail and court bail, so for children. So there are amendments to the Police and Criminal Evidence Northern Ireland Order 1989 and Articles 12 and 13 of the Criminal Justice Children Northern Ireland Order 1998. The department has highlighted that these changes aim to strengthen the existing presumption of bail for children. The committee may wish to consider the Department of Justice's Strategic Framework for Youth Justice 2022 to 27 in terms of how it aligns with these legislative changes, as it emphasises that children should only be placed in custody as a last resort. The framework document acknowledges that the existing legislative presumption in favour of bail for children is not operating as the department would like in practice. So it may be worth the committee exploring what difference the Justice Bill will actually make in this area. The bill also provides that bail conditions for children must be proportionate and necessary. It also includes an amendment to prevent children being detained in custody and refused bail because of a lack of suitable accommodation. So the committee may wish to consider how this will be supported by statutory partners, as at present a lack of appropriate alternative accommodation can be a factor in the use of custody. This part of the bill also seeks to underpin arrangements relating to the separation of children and adults in custodial settings, as it highlights that a child will only be held in a juvenile justice centre. And the bill also introduces a new youth custody and supervision order, which replaces a juvenile justice order for children aged 14 plus for less serious offences. So the duration of those orders will be for a minimum of 6 months, maximum of 2 years, and the detention period cannot be for less than 3 months and cannot be more than half the period of the order. So the committee might wish to consider the rationale for the introduction of this order and the replacement of the juvenile justice order. More broadly, and outside the scope of the bill, but one of the key issues relating to children and young people in the criminal justice system is the minimum age of criminal responsibility, which is currently 10 in Northern Ireland. And the UN Committee on the Rights of the Child has stated that a minimum age below 12 is considered not to be internationally acceptable, and it recommends between 14 to 16. Now, the department consulted on raising the minimum age from 10 to 14 in 2022, and the results of this consultation showed support for increasing the minimum age to 14, but this, as I said, is not something which is addressed in this particular bill. So, Part 3 of the bill relates to the use of live links in police interviews and detentions. So the department consulted on a range of amendments around this back in 2020, and at present a superintendent or above can authorise the extension of a person in police custody from 24 to 36 hours in person only. a district judge can extend the detention up to 96 hours with both the detainee and a police officer in court. And the use of live links for this function is intended to make these processes more efficient in terms of time and resources, as at present police officers, detainees and legal representatives may have to travel considerable distances. So there was broad support for these changes with appropriate safeguards in place during the 2020 consultation. However, concerns were expressed about using live links for suspect interviews where a police officer is in a different location. And concerns were raised by respondents around the ability of detainees to understand the proceedings, participate effectively, as well as any necessary safeguards for vulnerable individuals. So I've highlighted a few issues that the committee might wish to consider further in relation to this part of the bill. Really, is there an appropriate balance between the efficient use of resources and the needs of detained persons? Are there any additional safeguards for individuals undergoing live link interviews in police custody? Also worth thinking about how these new arrangements might be monitored, whether they should be subject to any review as well. And also worth considering if there's been any impact on access to justice for detained persons, maybe in other jurisdictions where similar live link technology has been used for interviews in police custody. So on to part 4 of the bill, and it covers a range of areas related to the administration of justice. So this slide highlights the various amendments being proposed, and they're covered in full detail in the paper, so I'm just going to talk about a couple of them today. Firstly, the bill addresses a legal gap by amending Section 7 of the Domestic Violence Crime and Victims Act 2004 to prevent a charge of murder or manslaughter from being no-billed when linked to an offence of causing or allowing the death of a child or vulnerable adult. And the no-bill procedure is a tool used to dismiss charges in the Crown Court before trial when evidence is insufficient. It might be worth the committee considering the background for why this change is considered necessary. This section of the bill also updates the Police Act 1997 to comply with the 2019 Supreme Court ruling on the disclosure of non-court disposals for under 18s. So essentially it clarifies in legislation that all spent convictions or other disposals of a person under 18 can be automatically considered by the independent reviewer prior to the issue of a criminal record certificate. More detail around the process for this is in your packs, but it's worth noting that a number of stakeholders, including the Northern Ireland Commissioner for Children and Young People, have called for a full implementation of Recommendation 21 of the Youth Justice Review around young offenders being able to apply for a clean slate at 18. However, the Department takes the view that a blanket policy of not disclosing any other disposals occurring when a person was aged under 18 in any circumstances could potentially create safeguarding risks to vulnerable groups. There are also changes to legal aid in terms of amendments to the Judicature of Northern Ireland Act 1978 to impose restrictions on the taxation of legal aid costs. It's envisaged that this change will support future introduction of alternative methods for determining the remuneration payable in relevant legal aid cases. So this proposed change stems from a report on managing legal aid produced by the Public Accounts Committee back in 2016, and the Department conducted a consultation on this issue in 2022. So there are a few issues that the committee might want to consider around this, in terms of might be worth thinking about whether restricting the role of the taxing master will actually give effect to greater predictability around legal aid payments. Also, what are the timeframes for alternative methods of remuneration being in place? Is there the potential for any impact to access to justice? And what remit will a taxing master have once these changes are implemented? So, in summing up, I've covered quite a lot of ground. This bill covers complex areas, particularly in relation to biometric data retention. So I will do my best to answer any questions the committee has, but I'd very much encourage you to seek expert evidence as well around this. I've already provided a few suggestions for witnesses in this area, but if there's anything else, let me know and I'll certainly do my best to find out. I know as well the Minister flagged that a number of amendments have been agreed by the Executive for planned inclusion in the bill at consideration stage, so they aren't considered in the paper or covered in the presentation at all at this stage. So anyway, I am all done, and thank you very much, Chair, and happy to take any questions anyone might have.
Thank you, Judith. Well done. Because this is not easy. It's a big bill, and we understand, of course, that you can't look at the next stage because we don't have the text of anything yet. So we understand that, but thank you thus far. Members, can I open up the floor to you to see if anybody's got anything? Doug, you indicating?
Yeah, Judith, thank you. It is complicated, and I was listening as I was typing, just so you're aware. But you mentioned the issue of the biometric retention, and that there is rules been put in place in regards to the Legacy and Reconciliation Act, so that could be retained. But given that some murders which took place quite some time ago are not linked to the Troubles, is there a chance of there being a legal conflict between one and the other in regards to this that you think could be there? In that, if somebody says, "Look, my wife was murdered in 1975, not Troubles related, and this stuff's going to be destroyed," is there a conflict? Do you think? Could there be a conflict?
Not sure that I can entirely answer that question, to be honest with you.
One for the department.
I think it might be better to ask the department maybe for a bit more detail around the regulations and just how that will, interact with this new retention regime that's being introduced under the Justice
I was just
Bill.
bouncing it off you, just in case you had the answer there
Well, I can certainly try and look into it for you and see if there's any more information I can find out.
there are a
about
number
it,
of murder cases that
well, there is,
fall into that
and some
category.
very recent ones actually. Where I guess the point that I'm making, Chair, is that conflict between somebody saying, well, the murder wasn't Troubles related, but you'll destroy this evidence, whereas this is Troubles related and you're retaining it. Is that conflict I'm really trying to tease out?
Which essentially could destroy somebody's hope of securing a conviction and therefore justice for their family member who's been killed.
Yeah.
So these are not by any stretch small issues. Do you have anything else, Doug, that you want to ask?
No, I was just going to pester Judith for that one. That's what.
But I think that is an important one for the department.
Yeah.
Because we're all aware of murder cases like that could be impacted here.
Yeah, and just sort of continuation of that. When does a live case cease to be a live case? Because presumably when it's a live case, it could be a live case for 25 years. You hear police saying the file remains open. Well, if the file remains open, then presumably all the material is retained. Who makes the decision to close the file? And does closing the file then either start the time clock running, or is the clock being running for the whole time from the day and hour the incident occurred? So yeah, there are lots of, I don't appreciate you're not going to answer these questions, but there are lots of complex questions which we're going to need answers to.
Yes, there are, because then if the case is going to be determined by actually how long you can retain the DNA, then the case ends up closed by default.
We can,
and in which case you could by de facto set a statute of limitations nearly by saying we're closing something by. And
there shouldn't be one.
No.
And in the non-troubles related arena, we can all think of cases that relate to constituencies or whatever that would be affecting. Yes.
Yes, and I mean, sure, that was part of the issue with the Legacy Investigation Branch.
Absolutely.
I mean, they had a number of cases that weren't troubles related but still fell into that remit. Any other members of anything else? Judith, I've got a few, but I'm going to, if you'll bear with me, I had a considerable number. So now I just need to work my way through and see what's better left for the department or somebody else than you. So if you just bear with me for a second as I work my way through. Yes, I think we're going to require more information about the custody photos. It seems strange to me that the department would just rely on the police's modus operandi currently, as opposed to just for completeness, including that. It seems strange, but I'll not ask you to comment on that. The live links. Sorry, let me just check in terms of that I've got everything in terms of the DNA stuff before we move, biometrics before we move on. Yes, Judith, if I could refer you to your report on our packs, it's page 48. Let me just see what page it is for you. It's page 14 of your pack. And there's reference there to the ICRIR, and then biometric material means a record of a DNA profile based on a DNA sample taken before the 31st of October 2013 or fingerprints taken before the 31st of October 2013. So, are retention regulations different for data taken prior to those dates? You know, what's the, can you just clarify for us the significance of that 31st of October 2013 date and what practical difference that makes to the retention of DNA?
I think that the regulations essentially allow for the ICRIR to hold a designated collection of material for use during the duration of its lifespan, and that is material taken
Prior to that date?
Prior to 31st of October 2013. That's my understanding.
Okay, and after that? I mean, that in itself could cause some difficulties, I think.
Yeah, I'm unclear about, maybe the rationale.
They will have a raft of evidence and forensic exhibits that they haven't been able to test against a DNA sample. But that's not to say they won't get a DNA sample in the future. Do you know what I mean? So, yeah, this stuff is not straightforward at all. I suppose I think I would like some clarification around whenever the ICRIR in theory finishes its work or not, what happens then to everything that it holds. But I suppose that's not for this bill, but I think it's going to impact this bill. Yeah, I have some concerns around the retention of material for those who are not convicted on two fronts. I suppose there's the rights issue of having your data retained if you're not convicted of a crime, but the other side of that is, again, the legacy cases where a lot of those investigations are still live and being looked at, and if those are destroyed, answers may never be found. And oftentimes, I suppose, the police know who has committed the crime, but what they need is the evidence base to pursue that with the PPS. So that this is why all of this stuff is important. Repeat convictions, page on our packet 65. Repeat convictions and the impact on retentions. Judith, could you talk to us about that a bit, please?
So you mean if somebody's already been convicted of an offence, and what would that mean for their retention of their data? So if an individual has been already previously convicted, it means that their data will be likely held for a longer period of time. I mean, it depends on the type of offence, so whether it's a qualifying offence or a non-qualifying offence. Also, again, there are various circumstances depending on the age of an individual, whether they're under 18 or an adult, as to which particular 25, 50, 75 year band it would fall into. But those are things that can be taken into consideration, and I mean table 1 in the pack sort of lays it out in full detail, but so you can tell by sort of the different type of offence, age, circumstances of the offending as to which category it would fall within for retention.
Okay. Then page 74 for us. children's personal data.
Yes.
What I struggled with in this was understanding what type of crimes fall into each category. I don't know if you're able to tell us today, or whether that might be something you could bring back to us in the future, but it's understanding, well, just what I've said, what types of crimes fall into each category.
So I suppose, the difference between a recordable offence, a qualifying offence, that sort of
And I know
thing.
you've put it in the glossary.
Yes. But if it would help to kind of pull that out more up front and sort of share that with the committee, I can do that.
Yeah, because it's one thing kind of to see what the definition is, but to understand, okay, what that looks like in practice.
Okay.
Let me see. So with regard to children, just want to flick through. Just please bear with me in this, because this is the chance we've got while you're in front of us. Yeah, I was interested in your point about the prevention of children being detained in custody and refused bail because of a lack of suitable accommodation. And I'm saying they want to kind of remove that, but the point is that's fine, but where do these children go?
Where do you go?
Yes.
Yeah.
Because I think the capital build on that now has been put on ice, hasn't it, because of budgetary measures. So it's all very well to include this in a bill, but if it can't be implemented, I mean, and there are risks then,
Yeah, I suppose it's about
for the
thinking
child's
of-
safety even.
Yeah.
Potentially.
How does that practically work?
Exactly. Yes. But we're being asked to. Yes. The distinction between the old orders and the new orders, for youth justice. What are the differences there beyond you're just allowed one order, and your order will have to keep, if you have repeat offences, your order will have to keep being updated? Are there any other significant differences there? I mean, the detention issue around your detention cannot be more than half your order. Presumably that's the same basis as adult sentences, where you serve half of it in detention and then you're on licence. Is it the same idea?
I'm not sure if that's the rationale behind that one. I mean,
With the department?
I think it's probably worth asking why has this order been replaced with this new sort of youth custody and supervision order, and just asking a bit more about what practical difference will this actually make.
From some of the evidence we heard last week, I can understand why, because individuals can have up to 11. I mean, there have been individuals who have been known to have 11, so it's very difficult to follow the conditions and the restrictions from 11. So you can understand why they put them down to 1. But in terms then of the breaches of these supervision orders, so the result can be more detention or a fine not exceeding £1,000. Is £1,000 proportionate, and how does that compare to your knowledge? And it may not be in your remit, Judith, but just in case you've covered this in your research, how does that compare to similar fines for adults in breach? I mean, I'll ask them how they got to the figure, but do you have any figures around comparability?
Wasn't something I looked into now in the course
okay.
of this, but again, I'm happy to try and find that out.
Don't worry, Judith, I think we can ask the department. Yes, page 90 of our pack, paragraph 3, there's reference to the bill removing provision to place a child on remand for the purposes of obtaining information about them. What does that mean, Judith? Can you give us an example of how that would currently work? Or what do they mean by that?
Yeah, I'm not entirely sure exactly what that means, but it does state it in the EFM that is one of the things that it is seeking to do. So I'm not entirely sure what information that might necessarily be, but it is that's sort of what it.
Obtain information about them. I mean, it's not very clear. There's a couple. Let me just write live links. I'm fine. My question's there for the department. Administration of Justice. Yes, Judith, please. Pages 98 and 99 of our pack, and I beg members' indulgence on this, but I want to be clear about this in my own head. I don't understand the no bill explanation. I see that there was no consultation on this by the department, and I don't understand why lesser charges shouldn't apply. Are you able to explain that to me, Judith, or is that another one that I need to speak to the department about?
It's probably another one that might be best asking the department about. Yeah, to me it wasn't immediately obvious what the rationale behind it was. That there may be a sort of technical reason there as to why that is in the bill, but I don't have any more information today that I could share with you that would assist.
Fine. I just don't understand. I actually don't understand what it means.
No, neither do I.
I'm glad about that, because I was thinking, I'm glad I'm not alone in that. I didn't understand the provision, but that's fine. We'll ask the department. Yes, it seemed to me, and this ties into some of the stuff that Liz mentioned, at page 102 on our PACS paragraph 1, there's reference to supporting future into alternative methods of determining remuneration in legal aid cases, and the AFM states provisions will not be commenced and will only take effect on a project by project basis. I mean, it strikes me, are we being asked to pass legislation, in the words of Donald Rumsfeld, on unknown unknowns? There's an issue around consistency there.
I'd imagine there's maybe they will have to go through and build, what the remuneration will actually, and specify it for each type of case that would potentially currently be being considered by the taxing master. So that's possibly why it says that.
Yeah, but essentially what they're asking us to do is agree something that's on a blank page. But that's for them. Let me see, page 1. I'm nearly there, Judith. And thank you, everybody, just for your indulgence in this. Page 103, paragraph 2. Yeah, the legislative provisions also make an amendment to section 32. Specifically, it removes the requirement that the expenses of a solicitor or counsel assigned to a respondent in vexatious litigant order applications be taxed and paid out of the legal aid fund. I don't understand that paragraph. Probably because I don't understand the system necessarily, but could you maybe elaborate on that a bit for us, or do you need me to ask that one of the department?
I mean, if it's helpful, I could. Is it more about the work of the taxing master that the committee is kind of interested in, or how that currently?
I don't understand what the paragraph means.
Okay.
Or respond in a vexatious litigant order, Who determines that a litigant is vexatious? Don't worry, Judith, I'll ask the department. I think that'll do me. I've asked quite enough there. Does anybody else have anything else that occurs to them while we've got Judith in front of us? No? In that case, Judith, thank you so much. That's a considerable body of work. We really appreciate it, and it's really helpful, and I have no doubt that your paper will be printed and alongside each of us as we move our way through the bill.
Say that.
So I'm sure we'll be calling on you again, but in the interim, thank you thus far.
Anything else? Any sort of specifics or anything I couldn't answer today that you can follow up on? Just let me know. Clark will let me know. Thanks very much.
Okay, thank you.
Members, just before we move away from issues around the bill, can I seek your agreement that we would commission further research from RAISE's Public Finance Scrutiny Unit on the financial aspects of the bill, and also as the clerk had raised earlier, if we could agree to commission legal advice on the bill.
Yeah.
I don't think there's any doubt that this bill's going to make it through second stage. So it's just so that we can get work started on some of these complex issues. Deirdre?
Yeah, no, I would agree with that, and particularly legal advice with a focus as well on human rights implications. And then also the point that was raised there now, I mean, we're developing legislation where the technology is well in advance, so I don't know where that's going to leave us in terms of difficulties presented. I know it's not just in this area, I think it was on the radio during the week in other areas of work and law, but just if there's any advice or up-to-date information on that, particularly around the retention of people's data, you know, is there any other advice? I know she touched on that some of the commissioners across the water have highlighted concerns. So is there any food at play that we're aware of that, for example, you know, the British government or even the Irish government are looking at to try and future-proof some of the legislation? It's even just to be aware of it at this point as we're moving through some of these clauses.
I think that's stuff we can check. I think some of that will come out, and you'll see Judith has left for us a list of potential expert witnesses. Yeah. And I think some of that will come out as we hear from those people.
Yeah.
So I don't think that issue will be missed as we move through. But certainly we can look into if there's anything immediately at hand. But the legal advice, I think, should pull out a number of these issues and direct us as to where we can go as well for some of these answers, and might then add to our witness list. And finally, members, before we just move off this, in the clerk's memo around the bill, I would draw your attention to the options at page 11. I'm not going to go through them now. I'm drawing to your attention so that you take them away, have conversations with your parties as necessary, and determine, I suppose, what you think is the best way forward, so that we can have an informed conversation about this and make a decision about how we call for evidence we go forward. Deirdre?
I was just going to ask you, I know the second reading's the week after next, so the timeline for when we have to make a decision then, have we penciled that into a future committee then for these options, and when is that? Sorry, do we have a date yet, or just so it's something that we can work to?
Yeah, the second stage is the 1st of October, so the committee stage will begin the next day.
Aye, so that's
assuming it's agreed, and then that's into the 30-day period in which the committee has to make its request for an extension to put that motion. So it will be within that period then. We have a couple of visits, I think, in October as well. So
that's what I'm thinking. So the first meeting after the 1st is going to be the 3rd.
So yeah, that will be
10th.
A short meeting, and the committee has training that day. There could be, we could schedule it in then, Chair.
Or even just an initial conversation. We might need more time, but it's just something that will come with a kind of rough timeline to work to, that we know a decision
it needs before a 30-day window.
Yeah, I know.
I'm not going to do this in 30 days.
So even room for an initial conversation on the 3rd, and then a date then further, just with, okay. No, that's fine, thank you.
Thank you. Members, if we can move on to agenda item 6 then, which is SR 2024-147, the Police Service of Northern Ireland and Police Service of Northern Ireland Reserve Injury Benefit Amendment Number 2 Regulations 2024. And I would refer you to pages 124 to 126 of the meeting pack, and pages 107 to 118 of the tabled pack. So let's just get ourselves together here. Pack is 107. Do we have officials coming in for this, don't we? Okay, while the officials are coming in, members, I just want to go through. The committee agreed that at last week's meeting it had no objection to this statutory rule. But after last week's meeting, the Department of Justice provided additional information that had not been available whenever we made our decision. Further to this, departmental officials have agreed to appear before the committee today to provide further clarification on the rule and to discuss what it has advised is a separate issue regarding the injury on duty scheme, the associated consultation and police pensions. Officials have been asked to provide the committee with information on the different schemes, the regulations to which they pertain, and any associated guidance, including forthcoming statutory rules. By way of background, at our meeting of the 30th of May, the committee unanimously agreed that it was content with the proposal for the statutory rule. The department has confirmed that there have been no changes to the policy content since the proposal was considered by the committee. But also an item of correspondence that was received from an individual regarding concerns about the review of police pensions was noted by the committee at its meeting of the 27th of June, and that led to our discussions last week. And I think it's to tease out some of those issues and to understand the distinctions between the two pieces of regulation that we wish to understand. So with that, I'm going to welcome Lynn Curran, who is the Head of Policing Strategy and Engagement, Antonia Hoskins, who is Police Pensions and HR Policy Branch, and Alan Crone, Police Pensions and HR Policy Branch also. Thank you very much. We appreciate you coming. There's been some confusion around this, so we welcome that you've come in front of us so that we can clarify some of these items. So I'm going to hand over to you to brief us, and then doubtless there'll be questions at the end. Thank you very much.
Thanks very much, Chair. Look, if I can go through a few speaking notes, first of all, it should take maybe about 7 or 8 minutes if that's okay, and then obviously we're happy to take questions.
No, that's great, thank you.
So, as you said, I'm Lynn Curran and I'm Head of Policing Policy and Strategy Division. My colleagues are Antonia Hoskins and Alan Crone, both from the Police Pensions and the HR Policy branch within my division. We very much welcome the opportunity to assist the Justice Committee in its consideration of the Police Service of Northern Ireland and Police Service of Northern Ireland Reserve Injury Benefit Amendment No. 2 regulations, and to provide clarification on the associated processes relating to police injury on duty and ill health retirement. I think it's important to set from the outset that these regulations are not related to, nor are they impacted by, the recent correspondence that the committee received. Okay, and we'll cover that later on in my statement here. What I would like to say is that in recognising that the issues relating to IOD, ill health retirement and pension schemes are highly complex and technical, we would like to provide some clarity today, but acknowledge that we may have to come back to you with some written briefing if there's questions that we don't immediately have the answers to. So firstly, the purpose of the No. 2 regulations and why the committee was being asked to agree this. So in the first instance, the purpose of the regulations is to place the medical guidance used by selected medical practitioners and independent medical reviewers onto a statutory footing. And secondly, to amend errors in the Police Service of Northern Ireland and Police Service of Northern Ireland Reserve Injury Benefit Regulations 2021. Members will recall that at your meeting of the 30th of May 2024, the committee was apprised of the outcome of the Chadwick and Harvison judgment, in which 2 police officers successfully challenged the board's decision not to implement an IMR's reassessment. The judgment found against the board, stating that it did not have the authority to reject the IMR's recommendation. The IOD medical guidance referenced in the court action was non-statutory, and as the court noted, it was non-binding. As a consequence, it was agreed by the board and the department that the said IOD medical guidance should be placed on a statutory footing to prevent the use of any alternative medical guidance relating to IOD awards. So the No. 1 regulations 2024 as drafted were to achieve this aim. At your meeting on the 30th of May, the committee agreed to the SL1 regarding the PSNI and PSNI Reserve Injury Benefit Amendment Regulations 2024, the No. 1 regulations. On the 9th of September of this year, the department wrote to advise the committee that despite the No. 1 regulations passing the statutory instrument validation tool, that at the time of registration, the Statutory Publications Office rejected the version that they had received due to unintentional errors that they found. So having engaged with the Departmental Solicitor's Office, the Statutory Publications Office, the Office of Legislative Counsel and the Examiner of Statutory Rules, it was agreed that new amendment regulations would have to be made, and that's the No. 2 regulations. They were required to replace and revoke the No. 1 regulations. The No. 2 regs were made on the 27th of June and came into force on the 2nd of July this year. And having received the 22nd report of the Examiner of Public Rules, the committee is now asked to consider the No. 2 regulations. And at this point, I think it's important that I'd like to reassure the committee that the errors were minor in nature and did not impact payments to individuals either positively or negatively. The second issue I'd like to address is in relation to the consultation relating to the proposed changes to the Police Service Northern Ireland Injury and Duty Scheme, and we are scheduled to bring our findings in relation to that consultation to the committee on the 24th of October. For a bit of context, the Northern Ireland Audit Office report Injury and Duty Schemes for Police Officers in the Police Service of Northern Ireland and the Northern Ireland Prison Service was published in March 2020 and made 4 recommendations. So in order to assess these recommendations, the IOD steering group was established along with scheme-specific subgroups, one relating to police and one relating to prison officers. The steering group and the subgroups comprised key stakeholders to take forward the relevant recommendations. Both the steering group and PSNI IOD subgroup agreed to a preliminary PSNI IOD targeted consultation, which issued in March of this year and closed in July of this year. The consultation sought views on a number of issues to help inform proposals to provide a sustainable, accountable and affordable IOD scheme for the future. Responses to the consultation are being analysed, and as I said, we will hope to bring that analysis to the committee on the 24th of October. Members should be advised that further work will be required from key stakeholders, including the PSNI and Policing Board, ahead of any recommendations for overall changes to the IOD award scheme. Consensus on any future changes to the IOD scheme and or associated legislation will be sought between stakeholders prior to ministerial approval, and the committee will of course be kept informed as matters progress. Members also sought some clarity on 2 distinct areas of work. One, the PSNI Injury and Duty Scheme and the ill health retirement from the police. I think it's important to point out at this point in this forum, it probably would be very inappropriate for us to get involved in individual cases, so I'd prefer that, with your indulgence, Chair, that we don't get into that level of detail. So with regard to the Injury and Duty Scheme, members hopefully will have seen the high-level synopsis that we have sent through. The key points to note from that are that the awards relate to those who cease or have ceased to be a police officer. The purpose of the award is to compensate for the reduction or loss of earning capacity as a result of an injury and duty. The IOD is not a pension scheme, and eligibility for award is determined by the Policing Board. And we're happy to guide the committee through the process for IOD awards as set out in the process map, if that's required today. And again, we have provided a high-level synopsis for the ill health retirement. The key points there are that eligibility for ill health retirement is predicated upon the scheme members making full member contributions to the voluntary 2015 police pension scheme. Members are required to hold a minimum of 2 years service within the police pension scheme to qualify, and the Policing Board, in its role as police pension authority, determines whether a police officer may or may not retire under ill health. Again, we're content to guide members through the process map that we provided to you. The committee here today also sought some additional information regarding matters to do with police pensions, which we hope to bring forward to you in the next couple of months. And these issues are separate pieces of work and are not related to the issue of injury and duty awards. So it's anticipated that the committee will receive a written briefing on the 26th of September relating to a forthcoming consultation to amend the existing bands and rate of employee contributions payable by the 2015 Police Pension Scheme members. This was agreed by the Minister of Justice on the recommendation of the Scheme Advisory Board. This amendment will address a shortfall in employee contributions identified in the 2020 scheme valuation carried out by the Government Actuaries Department. The committee will be asked to note the background to this matter and will be asked to note the commencement of a 6-week targeted consultation. Additionally, it's anticipated that later in the year the committee will be asked to consider the retrospective implications relating to the ill health retirement aspects of police pension regulations. The Department has given an undertaking to review the position of active 2015 pension scheme members who prior to the 1st of April 2024 were ineligible to apply for ill health retirement. Again, we're content to provide further detail today should the committee require it. And finally, I wish to address the issue of the correspondence received by the committee last week. And I think it's important that I reiterate here that the letter received has no impact upon or relevance to the Police Injury Benefit Regulations SR 2024 number 147, which the committee is being asked to consider today. For some just background information for you, the NIO report was commissioned as a result of the findings of the NIAO audit of the 2017-18 Northern Ireland Prison Service accounts and highlighted an issue with the increasing cost of the Northern Ireland Civil Service Injury and Duty Scheme, which is the responsibility of the Department of Finance. However, this work was later extended by the Controller and Auditor General to consider the PSNI IOD scheme, resulting in the report being published by the Northern Ireland Audit Office on the 10th of March 2020. We have engaged already with the Northern Ireland Audit Office in relation to the issues that were raised in the correspondence that you received, but we're not yet in a position to comment on the detail. I'd like to thank the committee for the opportunity of coming here today, and Antonia, Alan and I are now happy to take any questions that members may have.
Very much so. Horace.
Thank you, Chair. Two very short questions, which possibly short answers. Are you aware, is there a current or a pending legal action around the IODs and pension awards? Just a simple yes or no.
In what context?
That there is a legal challenge among former officers.
Are we aware?
Yes, we are.
We are.
You're
Yes.
aware. That's okay. Don't elaborate anymore. And perhaps you could furnish me with the level of detail that the selected medical practitioners went through on education and how they should perform their work in making these judgments.
They are provided with some training. There is a slide pack that we go through with them. They are furnished with the guidance, and they're made aware of the rules and regulations relating to the scheme, including the legislation.
Would it be possible for the committee to have a copy?
I don't see any reason why not.
That's fine. Thank you very much. Thank you.
Horace. Does anybody else have anything on this, Deirdre?
Just really, I mean, we were content enough with the ESR and stuff when it went through committee, but it's just really, it's come up at the policing board as well in terms of the remit for the injury of duty scheme really shouldn't sit with the policing board because they don't have the expertise or anything to deal with it. And that would be our party's view on that as well, in terms of it should be more appropriate to sit with the police. So any update?
That's actually forming part of the review that's ongoing, and that will be part of the consultation responses. And once we have the analysis done of the consultation, we will have to then look at what the next steps are, and they tie in with the 4 recommendations made in the NIAO report.
So, sorry, are you going out to consult that it should move to the police then, or...?
We are consulting on specific issues relating to there was a series of questions that were asked, and certainly we can furnish the committee with that consultation again if need be. But they all tie into that roles and responsibilities, who should be doing what, because they're currently set and embedded in legislation as to who is responsible for doing what within the scheme.
Okay, sorry, and is it it's coming on the 26th, you said?
24th of October.
Oh, October one, okay. And a written briefing or an oral?
The 24th, I think, is oral.
Okay, thank you.
Thank you, Lynn. Doug, yes.
Sorry, Lynn, thank you. Can I just ask a quick question? And it's on the retrospective injured on duty awards. And I'm looking at the questions that the SNP is asked to look at. But they're also taking one which I don't think is going to be a statutory question, and that is a start date for those who receive a retrospective IOD.
Okay.
And what we have now at this moment in time is that different officers are all given different start dates for their retrospective IOD. Some when they saw the SNP, some backdated to when it was identified that they may have been sick, some to their date of retirement. But what all of them have in common is that it was all proven that their injury occurred while on duty. So is it not sensible that if an IOD, a retrospective IOD has been awarded, that it should be to the date of retirement if that injury was found to be during their service?
And I've just been told that that's actually part of the legal case that's under consideration at the moment. So I'm not sure that it's necessarily appropriate that we can answer that just right here, right now.
And that's a fair one, and I'll not press you on that.
Okay.
But could I just ask then? But then the start date that the SNP's been asked to give, but that's not going to be one of the statutory questions, is it? You know, when this goes into when this goes through, there's a number of questions that the SNP has asked. The actual start date won't be one of them, will it?
I'm going to defer to one of my colleagues to answer that. Antonia?
No, not in because it's decided the start date is actually...
I'm sorry, and I'm only talking about retrospective IOD. I'm not talking about IODs, because normally injury on duty will be the moment they stop becoming a police officer. I get that. It's retrospective ones.
The retrospective ones depends upon the medical evidence that has been reviewed by the SNP. Right. So it's at the judgment of the SNP to provide that date.
Right.
Based on the evidence that is provided.
It's based on the case that's presented in front of them in respect of that individual.
But if the case that's presented in front of him means that he's saying that the injury is due to service, then it's during service that they've received that injury, so then surely...
Not always necessarily. So they may have received the injury during service, but it may not have manifested itself until down the line.
Yeah. But if I look at this through psychological injuries, for example, where somebody could leave the police service and not realise they've got a psychological injury, never do a single day in work from the day they left the police for 10 years, and then the psychological injury manifests itself.
I think what I would have to say there is, obviously, and apologies if anybody in the room is, but we're not medical experts here.
No, of course, yeah.
We have to rely on the advice that's given to us the board has to rely on the advice that's given to them by the medical practitioner based on the evidence that is presented to them. And I hear what you're saying, and I understand what you're saying, and maybe that's something that the committee would like to feed in as part of the consultation.
And look, and that's a fair one as well. You're absolutely right, because for policing board members, that's exactly the same, because they don't even get a paragraph. They get a line. And they make a decision based on a line from the doctor. They don't even get a paragraph outlining any of the information. So what you're saying is what the policing board is saying, and we're also of the opinion that it shouldn't sit within the policing board. But again, that's for the review. Look,
I think I remember going back when we were here in April, you asked a similar question.
Yeah, it was. Yeah.
And I mean, and the issue is that the roles and responsibilities have been identified as perhaps not being sitting as necessarily in the right places, and that will form part of the review, the bigger review that's ongoing at the moment that the consultation's feeding into.
But you make a very valid point, and that is, and I think it's the same for all of us here, if a doctor says this, who are we to say not? But that doesn't necessarily mean it's right, if you know what I mean.
And I accept that completely.
Okay, thank you, Jim.
Thanks, Doug. So I suppose just to recap where we are. With regard to the statutory rule that was in front of us, our issue was not any issue with that per se. Our issue was as a result of the correspondence that we had received, and we had thought that correspondence pertained to that statutory rule. So it's helpful to have clarification. So as I work my way through this, there's a couple of points that I want to make. In terms of paragraph 18 on page 128 of our stuff, if the board's rule is purely affirmatory, what options are open to them other than to rubber stamp a recommendation?
And I can't answer that because the process is owned by the board. So they are the ones who make that decision, and they are the ones who take the call.
Yeah, the issue is then when they did take a call, it was anything other than a rubber stamp. There was a pursuant legal case then, wasn't there?
I absolutely understand what you're saying. Yes.
And our party too would be in agreement that this shouldn't rest with the policing board. It should be, because essentially they have no option, and that's what I was trying to get to there. I note that the guidance is yet to be finalised. We've been furnished with the guidance from 2016, which is very clear that it makes it very clear within the guidance that it's not on a statutory footing, and obviously that's what you're seeking to remedy. But I suppose I'm wondering about the value of sending us guidance from 2016 as opposed to the guidance that's currently being looked at. And I understand that this was implemented in the 1st of July, yet the guidance is still being looked over by the department.
So
I mean, that seems strange and impractical.
But I think if I can remember correctly, and again I rely on my colleagues to keep me right here, placing the guidance on a statutory footing, it's not specifying which guidance, it's just saying guidance. So the review of the guidance is ongoing at the moment.
That's correct.
And where are we with that?
The guidance, both the policing board and the department have asked for legal advice on the draft guidance, and once we get that back, we'll examine that and then prepare new guidance or reissue guidance as the case may be.
And at that point, is there potential that there would need to be another SR to update? No. It's going to be fine.
Because the SR talks about guidance and it doesn't particularly specify the 2016 or hopefully the 2024.
So that takes us on to the correspondence that we received. Can I clarify what exactly that relates? I understand it relates to the audit office, but which of your which of your consultations is pertinent.
We don't believe any of the consultations are pertinent to the information that the individual has sent in. We believe it relates to the statistics that were quoted in the NIAO report.
Yes, I think that the outworking, I mean, from what I understand from the consultation, from the correspondence, is that the statistics that are quoted in that are likely to have bearing on whatever review you're conducting. And whatever consultation you're conducting, and that's why, I mean, I've read the department's response that says this is essentially a matter for the Northern Ireland Audit Office, and it is, in terms of the accuracy of the report. Those questions need to be put to the Audit Office and they'll need to answer. However, I think what we're seeking is, first of all, clarification as to which consultation is pertinent in terms of the Northern Ireland Audit Office statistics that are referred to in the correspondence we have received.
With you now.
And reassurance that you looked into the issues raised, because fundamentally the allegation is that if the Northern Ireland Audit Office got their stats wrong and you base a consultation on those stats, then the conclusion is erroneous. So the whole premise potentially is flawed, and that's what the query is. Now, from our point of view, we want to make sure that, having been alerted to this, all necessary steps have been taken to ensure that the stats are accurate or otherwise, and that where there is an impact then on a consultation that you would run, that it is not fundamentally flawed, that it is based on accurate facts, and therefore the outcome is accurate and right.
No, I understand what you're saying. And if you go back to my opening comments, what I said there was that we are actually engaging with the NIAO at the moment, and the policing board, to work through the detail of what the individual has put down in the letter, so that we can satisfy ourselves, satisfy the Minister, satisfy yourselves as well. So at this moment in time, I'm not in a position to comment on what that individual's done, because we haven't done a thorough analysis on it yet. But we will engage with the NIAO and the policing board in relation to the information that's been contained in this.
Lynn, could I ask, whenever you're coming to this committee on the 26th, was it 24th of October, whenever you're coming to the committee then about the consultation, is the consultation that you're coming to discuss with us the consultation to which the correspondence issues refer?
It will be related to it, yes, because the consultation that closed in July was one of the outworkings of the NIAO review. So yes, I totally understand the point you're trying to make.
Okay.
So, and yes, absolutely, on the 24th of October, we're happy to come and give you an update and as much assurance as we can give you at that time.
Right, and by that stage you will have been your discussions with the Northern Ireland Audit Office will have been finalised, and you'll have got everything you need.
I hope so, yes. We've already started to engage with the NIAO, and after this committee we will go back and we will engage with them and the NIPB. Okay,
I think it's just, from our point of view, it's an issue of due diligence. Because if somebody raises this with us, I mean, we've just seen Horizon. If somebody raises this issue with us and we are alerted to it and do nothing and take no action, then we also are remiss, and we just want to be sure that everything is based on the proper premise.
And I think it's an extremely fair point, and it's one that we're not going to argue with, because we're in a similar position. We want to make sure that the work that we're doing is based on fact. Because it's not in our interests, it's not in the interests of the members of the schemes, it's not in the interests of anybody sitting in this room that something is going out into the public domain that is fundamentally flawed. At this stage, I can't say whether it is fundamentally flawed until we do further analysis.
And that's absolutely fair. I think what we needed was, we weren't clear to which it related. We wanted to assure ourselves you've clarified that point for us, and then we'll follow up when the time comes. And obviously we note that at the end of that correspondence there's reference to issues within the policing board, but that's not relevant to the issues that we had concerns around at this point and queries that we were asking. So I think that's us. Does anybody have anything further on this? No? So on that basis then, can I ask members, we had taken a decision last week but it was almost like a parallel process. We had still indicated that we were content with the statutory rule. Now that we've had clarification that the correspondence issues don't pertain to this, and we'll have a further opportunity to get reassurances around that, are we content to proceed with statutory rule 147 as we had already agreed?
Agreed.
Yes? That's great. Thank you very much.
Thanks
Folks,
very
can
much,
I
Chair.
thank you very much for taking the time? That was really helpful for us.
Thank you.
We appreciate it. Thank you. Agenda item 7 is the renewal of the Secretary of State's direction under Section 1A7 of the Prison Act Northern Ireland 1953 as amended by Schedule 4 to the Northern Ireland Act 1998, Devolution of Policing and Justice Functions Order 2010, Department of Justice written paper. So I'd refer you members to pages 227 to 235 of the meeting pack for the relevant papers. The Secretary of State's decision under Section 1A7 of the Prison Act Northern Ireland 1953, as amended by Schedule 4 to the Northern Ireland Act 1998, Devolution of Policing and Justice Functions Order 2010, stipulates that the Department of Justice officials, when dealing with operational prison matters that remain in the reserved field, are to be treated as officers of the Secretary of State and are subject to his direction and control. The Minister of Justice received a letter from the Secretary of State seeking her views on the direction, specifically on its content, how it's operating in practice, and any other matters that she considers relevant. The Secretary of State is proposing a renewal of the direction for a further 12 months from November 2024. In 2011, by way of background, the then Minister David Ford indicated that he wished to consult formally with committee members and to seek their views before each annual renewal of the direction. Consultation has taken place on an annual basis since then, with the exception obviously of those years when the Assembly was suspended. The current Justice Minister is of the view that the direction remains fit for purpose and that it doesn't need to be amended and that it should be renewed from this November. However, before she does agree to the renewal, she's seeking the committee's views. Are members content with the renewal of the direction, or do you require any further information or clarification?
And, we're not aware of any legal challenge or anything pertaining to this, are we?
It's been ongoing for quite a number of years.
Yeah.
No, I don't think there has been any.
Nothing
There's
in the
never been
last
any,
year,
no.
okay.
Well, not that I'm aware. Are officials aware of anything?
We need to check with the department chair.
Do you want us to check?
If we get clarity, it would be useful, I think.
We'll get clarity and then we can be certain. But
Yeah, no, it'd be good.
it
Thank you.
seems that predecessor committees for years now have
Just renewed
agreed to
this.
this, so I don't envisage. But we'll check just to be sure.
Okay.
Members, if I could direct your attention then to item 8, which is before I do that, can we just note the contents of the written paper, just for the record? Thank you. Agenda item 8 is the forward work programme, which is pages 237 to 248 of your pack. So there are two options for a potential committee visit, which has been provisionally scheduled to take place on the 28th of November. The first option would be to visit Inverary House, which is a 12-bed homeless hostel based in East Belfast that provides safe accommodation and support for individuals with mental health problems in a residential setting. That's the one that kind of has the wraparound care that's run by Mindwise. The other option is to visit one of the projects from the Executive Programme for Tackling Paramilitary Activity and Organised Crime. So that really could be whatever we so chose. The first relates to our mental health inquiry. The second option would be, I suppose, our scrutiny of departmental projects and so on. So it's up to members to decide what their preferred option is.
Practical to do both. Not practical to do both.
Chair.
Not that day for sure.
That day. Certainly one could be added on a longer finger. I would just caution a bit, I suppose, that schedule's filling up very quickly with bill evidence and other things as well, but it could be added onto the longer term list.
Deirdre?
I was nearly inclined to say the Inverary House one, because we're going to be doing a number of sessions around like mental health and pressures on the justice system.
Yep.
or maybe you could say we're already doing enough on that, so maybe look at the paramilitarism one, but I would nearly go towards the mental health one just because of the pressures, but I'm open if somebody thinks differently. Like,
Sure, I'd agree. I think sometimes it's best to focus on one and do it well, than too many. So I would agree.
Agreed.
I'm really glad about that actually, because this struck me as something that was really best practice, you know, where people learn to live in their own environment. They're helped along. There's always somebody there from day to day to give them a bit of encouragement and advice. There's wraparound care for people who are homeless, people who've been through the system. And the thing that struck me about that visit was that's where a person who'd been through the system said to me, it's almost like we're being teed up to fail. So to see this, and this hostel has a really high success rate, and it is known amongst the community that if you get a place in this house, in Very House, yes, you're likely to break the cycle. So I think it would be really valuable for us to see that. So I'm delighted if that's the one members have chosen. So thank you. That's not ruling out, I think, of us to a project as we move down the line.
Yeah, I can add it onto the list for longer term.
Thank you. Is there anything else in the forward work programme members want to raise, or are you content to note?
yeah, just the only thing I suppose is, I know we're going to go back to McGabry, but at some point, do the likes of McGilligan and stuff as well. I don't mean for now, because obviously we're going to have the first bill and stuff, but just to kind of hold it for some point in the mandate.
I think McGabry chair is important because of the pressures on the prison system at the moment. I think we need to see at first hand the doubling up and that. You and I were there and saw some of the effect of that earlier on this year.
Where McGilligan?
No,
I wasn't at McGabry.
Oh, sorry, at McGilligan we saw doubling up as well. So yes.
Go to McGilligan when they've finished the kitchen and cafe first.
100%.
Get it like slot.
Yes. The 13 million
Million
one.
cafe and kitchen, yeah.
Well, if you saw what the old one is and about the fact that
I've
it's likely
seen.
to slide into the sea.
Oh, no.
That's right. I suppose the issue is that another couple of million onto that and you'd have a full school as opposed to just a canteen and cafeteria. But anyway, we appreciate that there's need in McGilligan, but the issue is to make sure that all money is wisely spent. And I suppose we don't want to see a kitchen that's Gordon Ramsay standard. Right. Agenda item 9 is correspondence, and there's 9 items of correspondence going from page 249 to 549 of your pack. I'm going to draw your attention to a number of the items, and then I'll open the floor to members if there's anything they want to comment on or in which they've got a particular interest. At item 9.2, there is a report on the operation of the Protection from Stalking Act from the Department of Justice at pages 252 to 261. The report does not include the average time in conviction cases, as the department advises that collecting this, in quotes, would result in disproportionate costs, or there's a breakdown of conviction cases with behaviour engaged by means of the internet, as quotes, as this data is not available. There are provisions that require this information, and they were brought by ministerial amendment at the request of the predecessor committee during the bill's passage. So I'm asking your agreement to note this item and whether or not we should write to the department to seek further explanation as to why the information required by the Act is not available and what steps are being undertaken to ensure full departmental compliance with its duties under the Act. Are members content with that?
Agreed.
Yeah.
Item 9.4 is correspondence from the Committee for the Economy, and that's at pages 281 and 82 of the meeting pack, and it's around the informal meeting with the Association of British Insurers. I would ask you to note this item and advise you that the informal meeting with the ABI and the Committee for the Economy was going to take place on Tuesday the 15th of October at 1 p.m. The joining details for that and an agenda will follow in due course. Item 9.6 is correspondence from the Committee for the Executive Office at pages 293 and 94 of the meeting pack regarding a request for a formal response to the draft programme for government. I'll ask you to note this item because departmental officials are going to provide evidence on the draft PFG at our committee meeting on the 10th of October. Content to note? Thank you. Item 9.7 is correspondence from the Committee for Finance, and that's at page 295 to 316 of the pack, and it's with regard to the budget 2025-26 timeline, budget commissioning templates, which are actually very helpful, and scrutiny of budgeting for the PFG. Could I ask that you note this item and consider this correspondence further as part of our budget update October monitoring oral evidence session and our meeting on the 26th of September, and during the draft PFG oral evidence session on the 10th of October. Thank you. Do members have anything else in the correspondence they want to raise? I'm just checking if I do. Nope. Everybody content? Happy to note?
Noted.
That's great. Thank you. Agenda item 10 is chairperson's business, and there is none. Agenda item 11 is any other business. Does anybody have any other business they wish to raise? Deirdre?
Just one, sorry, it come up, I know it was issued, it was the Criminal Justice Inspectorate report.
Oh, today.
Just into court service and errors, and I think it was the Irish News that reported it today. Just with the headline around 10,000 court service errors, which could have had dire consequences. So it's just to say, I should have maybe added it in the work programme. Are we due to meet the inspectorate again, or maybe it's a broader emerging issue we need to look at in terms of the pressures within the system?
Do you visit to the court service at some stage of that too?
So maybe we could pick it up as part of. I can circulate the article as well.
That would be helpful. I haven't seen that.
I'll send it to Caroline and she can send it across. But it's obviously pertaining to the report that was issued at midnight last night.
Yeah, Chair,
We could maybe pick it up on the visit or something.
I briefly scanned the report early this morning when it came into the inbox, and I have to congratulate the Commissioner because they've set some very tight timelines for actions to be taken. So it might be useful for us to have a conversation with the court service just to see how they're meeting those targets.
Yes, I presume that that report will be in our pack anyway.
It should be,
Yes.
Which will afford us an opportunity to, I'm supposed to get a proper look at the report and then decide how we wish to take it forward and get some timelines around that what we want to do.
Yep.
But I think at this stage there are a number of emerging issues. There's the issue that Justin raised about breaches of licence. There's the issue around this, and there was another one that occurred to me there, but it's gone.
Complaints by
Pardon?
complaints by prisoners as well.
That one was something else. Breaches of licence. Yes, sickness levels. The DOJ has the highest sickness levels across the civil service. So there are a number of emerging issues, probably that we do need to take a look at, and we'll need to factor those in, just on top of all the other stuff that we need to look at. But at least that keeps us busy, and it's all stuff of interest and help. Justin, did you indicate there? Justin, are you trying to talk to us?
Microphone's
yeah.
Yeah, I think the issue is that he's being muted by Assembly Broadcasting and he can't get it off.
She had said something similar around there.
Okay. On to
This
on to
one.
the
we can
presenter.
contact them.
Lost sound or something from the meeting.
I think that's him.
Hi guys, no, I wasn't indicating my point. Like across the screen. Apologies.
After all that, you could have done a thumbs down. Thank you. All right, there's no other business then. Agenda item 12 is the date, time and place of next meeting. So that's going to be next week, which is Thursday the 26th of September at 2 p.m. in this room. Everybody, thank you very much. The meeting is adjourned.
Committee Room 30, sound. 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 Committee Room 30, sound.